Hello, everyone, and thank you for joining us for the latest in our series of summer webinars. The series is designed to bring you insights from industry experts into key issues that are percolating around the market, and today is no different. I think the main difference is we have not one but three experts. I'll allow you to guess the odd one out from that list. It's me, in case you're wondering. But we've got three industry experts who are going to be talking about the relatively recent changes to the non-dom tax landscape. Fair to say that didn't necessarily go the way the government expected or planned, and certainly has created a number of new planning challenges and opportunities for advisors. So delighted that we've got some expert speakers on that, and I will introduce those to you in just a moment. Just before we get into that, though, there are a couple of housekeeping points I'd like to share. Firstly, the obligatory compliance warning. So this is a financial promotion. That said, it's not designed to offer any kind of financial advice. Clearly, all investments carry investment risk, and when it comes to the Foresight range of products, there are also liquidity concerns there as well. Nothing here is intended to be taken as a kind of definitive answer. We will take you through some example scenarios, but would encourage you to seek specific professional advice if you intend to act on anything that you see or hear today. Couple of other points to raise. We do have an hour for today's webinar. I think we have about 45, 50 minutes worth of material. We have deliberately tried to leave some time for Q&A. If you'd like to ask a question, it kind of depends on your screen setup, but if you move your cursor to the bottom of the screen, you may well see a Q&A box there. If you do, please just type your question and we'll try and pick that up at the end. If you don't see that Q&A box, but you click on More, which should be a sort of circle with three tabs, that should give you an additional set of options, and you should find the Q&A in there. Again, we have allowed some time for those. If we don't have time for all the questions live on the webinar, we will endeavour to respond to you directly after the webinar. So hopefully everyone will get an answer to the question that they've posed. And a final bit of housekeeping. There will be a survey at the end of the webinar. I think it pops up when you come to log off. That's just your opportunity to let us know both how we've got on today, but also other topics that you might be interested in hearing about. As I'm sure you've recognized already, an awful lot of what we're trying to do in this summer series of webinars is bring you information on areas that Foresight wouldn't normally speak to you about, and indeed, Foresight are not necessarily experts. We're trying to do that to add some value to you as advisors. So if there are other areas that would be beneficial, then please let us know and we'll seek to find the best quality speakers that we can. Next slide, Tony. So as I've mentioned, four speakers. For those who don't know me or haven't heard from me before, I'm Huggy Clark. I'm one of the partners in the sales team at Foresight. Been with Foresight just over 10 years now, but you definitely did not come to hear from me. So I'll hand over to David to introduce the rest of the team.
Brilliant. Thank you very much, Huggy, and good morning, everyone, and thank you for joining. So, as Huggy said, the focus today is the UK's new regime for the taxation of individuals and families with international connections, which was introduced, you might recall, in the infamous autumn 2024 budget. You might remember that was the one where the government had identified this fiscal black hole of 20 or 30 or 40 billion pounds, depending on which day it was, which needed plugging. And the changes to what was the old non-dom regime were a big part of that. They'd been in the planning for a while. But that's what we'll be focusing on today and the practical ramifications of that. So, by way of brief introduction, your three speakers today, we're all from Edwin Coe, which is a central London law firm. We are based in Lincoln's Inn in London's legal district. We have 45 partners and about 250 staff all told. And the focus of the firm is very much on private capital and private wealth. So we have a range of legal departments. We can cover most of the legal needs of high and ultra high net worth individuals and families. Specifically, we have many of our departments are focused on those needs. So, for example, our corporate team focus particularly on the work with entrepreneurs and other business owners. We have a property team that specializes in particular in high value residential real estate and commercial real estate. We have an immigration team for international people looking to relocate here, and also employment and intellectual property specialists, and a lot of particular specialism in litigation and dispute resolution, which can cover a whole range of topics, particularly commercial and general litigation. But one growing area of that is in the area of private wealth disputes, so trust and estates disputes, which we are seeing an increasing focus on. All three of us are members, though, of our private client team. We're a market leading private client department, and we carry out the whole range of work you'd expect from that area. So, obviously, the central focus is on wills and estate planning, but then using other structures to handle succession planning. So, particularly traditionally trusts, but as you will see in today's world, we're looking at other vehicles as well, increasingly to help to manage the transition of wealth across generations in as an efficient way as possible. In terms of our team, specifically, we have six partners focused on private client work and about 25 staff all told. And I'm a partner in the team, and my co-speakers this morning will be Eva Moynihan and Toni Recchia, who are both senior associates in the team. And all three of us focus increasingly on private client work with an international dimension. As I mentioned, that can be quite a broad term. It means we deal with what traditionally would have been non-doms. As we know, that's no longer really the relevant term anymore. But international people who've come to the UK or invested in the UK for various reasons. But of course, we also deal with regular Brits with overseas connections of all sorts. And it is worth saying that even if your clients and contacts are primarily UK centric, there hopefully can still be a lot of relevance in looking at this new regime because, of course, as we all know, wealth is so global now that it's highly likely that clients may well invest overseas, have a holiday home there, or they have close family members who go to study overseas or work there, and that brings in other jurisdictions and international taxation into the piece. So, with that said, just touching briefly on what we're looking to cover this morning, we'll be focusing on the key features of that new long-term residence regime, referred to as the LTR regime, which has replaced the previous non-dom regime, which had been around in one guise or another for the last 200 years, and then been added to and taken away from over the years. We're going to describe in particular the impact and focus on the impact of this new LTAR regime on specifically inheritance tax, also foreign income and gains, and the tax treatment generally of internationally mobile clients. And one thing we'll be focusing on particularly, though, is the practical implications of the new rules. Specifically the FIG regime, as it's called, that's foreign income and gains regime, which is a major part of the new taxation rules. The number of transitional provisions that applied to the long-term residence rules when advising clients with all sorts of offshore connections, whether those be just assets overseas or in particular international trusts. And we'll also try to look at the potential planning strategies that are in play at the moment. It's very much a movable feast because we're still in the relatively early days of this new regime, but we'll try and share some of the experience we've had of working with clients and some of the techniques and solutions that seem to be particularly popular for clients who are exposed to this new regime, particularly the use of offshore bonds, family investment companies, trusts, which have had to be adapted quite a bit, and also specific residence planning to try to help clients manage this exposure and the whole new regime. So with that said, I'll hand over, I think, to Toni to begin with, just to talk about the changes in a little more detail.
Thank you, David. Good morning, everybody. So we just want to start by giving a very brief overview of the key change here, which is, of course, this introduction to the concept of long-term residence. So as I'm sure you all know, the changes took effect from 6th of April 2025. And in a nutshell, what that's done is replaced the concept of domicile with this idea of long-term residence. So when we're thinking about who might be a long-term resident, and in particular the clients that this might apply to, we're thinking about those people who are potentially arriving to the UK with a plan to stay here for a considerable period of time, people who are leaving the UK and have potentially already been here approaching that 10 years or 10 years plus, or those that are planning to stay here and have been here for that 10 years plus, or again are reaching that milestone. And perhaps would have looked to take advantage of the non-dom regime or would have been deemed dom. So that's just an idea of who we're talking about, or who you might be talking to that this might apply to. And as we've just mentioned on the slides there, the objectives for these changes from the government's perspective were to simplify the tax system. The concept of domicile they were finding it to be a bit ambiguous. There were lots of challenges. And the idea was that having a residence-based regime would make things much simpler. It's a case of counting days, looking at ties. It's very clear-cut. You either are a resident or you aren't. There was the idea that it would encourage investment into the UK. I don't know if we're really seeing that just yet. Perhaps you are. But I guess time will tell with that one. And also to broaden the tax base, which I think is the case here, because we are finding that a lot more clients are now being caught in the inheritance tax net and UK tax net generally, which perhaps with domicile maybe wasn't always the case. So just looking at long-term residence in a bit more detail and what that's done and the impacts for clients. So as we've mentioned, it's replacing this idea of domicile with residence. So it's really important now that clients are thinking about how much time they're spending in the UK. And part of the work we've been doing is a lot more statutory residence test advice. So really looking at those internationally mobile clients and the ties that they're keeping to the UK and the number of days that they're spending here. So it's really, really important that they're keeping an accurate record of that and being really mindful of their connections to the UK. If you are a long-term resident, what does that mean for you now? Well, generally it means that your global assets are now subject to inheritance tax. So it's no longer just the case that your assets in the UK would be taxable. And another key change there is if you are a long-term resident or you were previously taking advantage of the remittance basis as a non-domicile individual, that's now been removed. So there's no longer the remittance basis available for those non-doms. Unfortunately, there's been no kind of direct equivalent replacement for the remittance basis, but there has been the introduction of the foreign income and gains relief, which we'll go on to in a bit more detail shortly. But the key takeaway here, when we're looking at clients with long-term resident status or coming up to that point, is just to be really mindful of the planning, make sure that they're looking at this in advance and not just leaving it until the last minute. Because clients, as we've said, need to be more mindful than ever of their days spent in the UK and ties. Okay. So if we just take a quick look at the foreign income and gains regime in a bit more detail, and firstly, who this would apply to. So we're looking here at clients who are new to the UK, so have never been UK tax resident before, or potentially clients that have been UK tax resident before, but have been outside of the UK for a period of at least 10 UK tax years. And what the relief offers is 100% UK tax relief on certain foreign income and gains. that are brought into the UK within those first 4 UK tax years of residence. It's really important to note, though, that your 4 years or your client's 4 years begin from that first year that they arrive in the UK. So if they decide to arrive for 1 year and then leave and come back, it's a consecutive 4-year period. And just as an example of how that might apply, so you could have a client, I think we're going to go on to an example later, but just could have a client who has an offshore portfolio outside the UK, comes into the UK and wants to keep it outside and take advantage of bringing that income into the UK without being charged on the UK tax, and that would be possible for them. So it's not a direct replacement for remittance basis, but it's more of a soft landing for those clients. Unfortunately, though, there is still that cliff edge after the 4 years when worldwide income and gains would then become subject to UK tax if they continue to be a UK tax resident. So again, I think you'll see there's a bit of a running theme here that the three of us will be talking about of how important it is for clients to plan in advance and be really clear on what they're doing and how long they might like to spend in the UK and how they might like to plan for that. There have been 1 or 2 further transitional provisions, which we just thought might be helpful just to quickly touch on. One of them being the temporary repatriation facility. Again, kind of a bit of a soft landing for those that might have previously taken advantage of the remittance basis. So where you have those clients who were previously non-dom and using the remittance basis, they now have the opportunity to bring in any historically unremitted foreign income and gains into the UK at a reduced flat rate. So this started when the rules were introduced, so the first year, 25-26. And for the first 2 years, the flat rate was 12%. So it's 12% until the end of this current tax year. And then next year it will increase to 15%. It does actually end at the end of the 27-28 UK tax year. So there isn't that much more time to take advantage of it. But if you do have clients that are in that situation and could benefit from that, it's a good one to know about just while the time period lasts. The second point we've mentioned there is just on the inheritance tax tail, not necessarily a transitional provision, but more of a kind of a transition for clients who are leaving the UK. If you are an LTR and you look to leave, you are now in the same way that you were as a deemed domicile, followed by an inheritance tax tail. But under the old rules, it was limited to 3 UK tax years, whereas under the new system, it's on a bit of a sliding scale where, depending on how many years you've spent as a long-term resident in the UK, will then depend on how many years you have for your tail. So it could be up to a maximum of 10 years after leaving the UK that your global assets are still subject to inheritance tax. But as with all of these changes and with the changes of the rules generally, they are all quite complex and sort of case specific. So I think it's definitely worth clients taking advice and reviewing their position again before they leave the UK, before they arrive, or before making any significant changes. So we're going to look at the impacts for clients in a bit more detail. So I'm just going to pass over to Eva to talk about that.
Thank you, Toni. So we thought it would be useful to run through how you might be seeing this affecting your clients. And as Toni mentioned, because of the removal of the remittance basis and this shift towards the residence-based system, clients whose worldwide assets were otherwise not in the UK tax picture could very much be exposed to tax. So we are seeing an increased interest in investment wrappers, especially those that can be offshore. They're becoming more central again, and we'll discuss them in more detail later on in the presentation. But as a result of some clients and individuals now being caught in the UK tax net where they were not previously, because they could be classed as long-term residents, they may well be looking at doing some liquidity planning. So you may see that prompts some of those types of conversations as a result. as we'll discuss again later on, and as Tony mentioned, there is a much greater emphasis on pre-arrival planning. So for clients moving to the UK, or even for those potentially spending more time here, they need to really watch their days, as they could very well be caught more easily than they were before. So moving on to our next slide, we thought it would be helpful to run through some what we call myths versus facts. Many clients are coming to us with sort of headlines or things they're seeing in the news, and it could be useful to provide you with some more background and information surrounding those, as well as our own practical experiences. So the first one we have here is non-dom rules still apply. As Tony ran through, domicile is no longer relevant for tax purposes and has been replaced by a resident system, but it is useful perhaps to know that domicile does still come into play for succession purposes, for double tax treaties, and for 1975 Act claims. And then our next myth here is leaving the UK removes IHT risk. As Tony helpfully went through, immediate leaving the UK will not necessarily remove all tax exposure and risks for clients. The tail means that they could very well still be caught for some years. So clients need to be alive to that fact. Our next one we have here is offshore equals tax-free. Although assets and individuals could move or be offshore, this does not necessarily mean they are safe from the UK tax net. Increasingly, and after the new rules, for example, offshore excluded property bonds, trusts, could now be caught, and that very much depends on the resident status of the settlor at the relevant time. We'll go into this in more detail later on, but sadly, it is not as clear cut as it used to be. Trusts solve everything. Well, we very much think trusts still have a place when it comes to planning for clients. However, since the new rules and even over the last decade, new legislation has been introduced, which has slowly removed some of the more advantageous aspects. But there are still very much some advantages in place, and it is highly fact specific. So it is useful to look at for clients, as it could be very useful tax planning tool for them. And so now coming on to the next one, everyone is leaving the UK. This is probably the most common phrase we've heard since the new rules were introduced. And although it is probably true that some people have chosen to leave as a result, we personally, us three, haven't had a client leave as a result of the budget. There are plenty of people staying, and also plenty of people arriving, particularly US clients. We are seeing many more inquiries in that respect. And then finally, the last myth we have here is that less than 90 or 100 days are fine. We often have clients coming to us with a very sort of set number of days to say that they're fine because of this. And unfortunately, the statutory residency test is quite complicated. And so we would advise people to make sure they do that detailed analysis, as there are many different factors that come into play that will determine the number of days a client can be in the UK to make sure they are safe. So we often sort of have people coming to us saying that other intermediaries have given them their set amount of days, but it's good to be alive to the fact that this should be reviewed, and they should be aware that things could tip the balance and change their number of days. And so I think David wanted to touch on the reality of that and discuss some client situations.
Yes, indeed, Eva, thank you. And I think I particularly just wanted to pick up on those last two myths that Eva was just mentioning there, because we really have seen an awful lot of chat about those, and it keeps coming up. I think in particular that statement, everyone is leaving the UK, or at least all high net worth people will be leaving the UK. I mean, that really came out in some ways. This budget was one of the most heavily covered in the national press that I can remember for many, many years. There was so much speculation in advance of it, partly fueled by the government itself, trailing all sorts of rumours. But in particular, since the budget, we've just had sort of blanket coverage to say that, you know, the UK is no longer an attractive location for the internationally wealthy. And I think it's exactly as Eva said. Of course, there have been many clients who have left the UK as a result of it. We can't, you know, that is the case, generally speaking, and there have been particularly some high-profile departures. But I do think it's important to, you know, to keep some kind of sense of proportion on that. As Eva said, you know, from ourselves personally, we have not seen that many, or if any, clients who actually left the UK directly as a result of the budget. Some had left in advance of it. Some have continued to talk about leaving and taking advice on it. One or two did leave temporarily, but have come back. So, you know, it really is, it's a more nuanced picture than the press coverage might have you believe. And as Eva says, we're also seeing new clients arrive. And again, it's probably true we're having fewer international people come to the UK than might have been the case in the past, but you can't quantify that. We're definitely seeing new arrivals, particularly from the US, but from all over the world as well. So I think important to keep that sense of perspective, and to keep the message out there that, you know, although it's true that the new regime is not as beneficial for international individuals as the previous one, there are still plenty of planning opportunities, the ones we'll be coming on to focus on. And so, you know, the UK is very much still in play as a destination for international wealth. And then just also to pick up on that last point, time and again we hear clients saying, well, it's fine, you know, I've been in the UK, or I'm planning to be in the UK less than 180 days, you know, or less than 6 months. So that's fine, isn't it? I'm not resident, so move on. And even pretty sophisticated clients can often come up with that point. And it's just to keep reiterating, we have a much more complex and nuanced test of whether you are resident or not that's been applying now for the last 13 years. It's the statutory residence test, as Eva mentioned. I'm sure you all know, it has many different variables that are taken into account. The day count that you spend in the UK is just one. It's an important one, but there's many other connecting factors that can apply, including whether a client has accommodation available in the UK, other family members, whether they work in the UK or not, and their recent history of the number of days they've spent, not just in this current year under consideration, but the previous 2 years as well. So it really is worth doing that analysis with the client to work out, are you definitely tax resident under the terms of the specific legal test or not, and have you been in recent years? So that was just some commentary from what we're seeing in practice, but just moving on then to the what we want to cover next. And as we mentioned, we wanted to focus in particular on sort of the practical implications and what we're seeing in terms of planning techniques. And there's sort of 4 areas there that we've particularly identified that we are seeing a lot of traction on. The first one is to say that offshore bonds, to some extent, in some circumstances, are coming back into their own as a planning tool for international clients and families, particularly in the context of trusts. For various reasons we'll explain, they can work well, but always subject to the right fact pattern. Same point really applies to family investment companies. Obviously, they've been around for quite some time, particularly focused on UK domiciled clients as a planning tool. Because of that, then they're now, in light of the new rules, being adopted by international clients a lot as well. Again, they can be a very useful solution, but definitely not one size fits all. As I think we'll come on to and touch on, they can work very well in certain specific circumstances. We'll also touch on trusts again. As Eva mentioned, it feels like trusts have been under attack, and the new rules have narrowed down the opportunities for trust planning. But again, they still very much have a place, and in particular if they're put into a hybrid structure, so maybe combining a trust with an offshore bond or with a family investment company. That's still very useful planning nowadays. And then lastly, as we've mentioned, just being much more aware of the details of residence planning. We're seeing a lot of clients who want to really be quite precise, still retain lots of links to the UK, but keep themselves as non-tax resident under the rules. So we'll just go through each of those in a bit more detail. And to begin with, I think it's across to Eva just to talk about offshore bonds in a bit more detail.
Yes, of course. So, as David mentioned, offshore bonds have re-emerged as a key planning tool. They could particularly be helpful now that the remittance basis is gone. We usually see these working in the context of an offshore trust. And so it would act as a wrapper between the client or the trust and a portfolio. Many of you will know much more than us when it comes to the running of an offshore bond, but as a concept, it's very much has a place now, particularly under the new rules. So the way in which that offshore bond works is that you can take, well, the client or can take 5%, so being 5% of the initial capital of the bond, and that does not itself trigger an immediate UK income tax charge. The charge is postponed to a later chargeable event, which would typically be a full surrender, an assignment, maturity, or death. If that 5% is not fully utilised, then it rolls up and it can be withdrawn in the future if it remains unused. So this 5% deferral rule is often referred to as the 5% allowance, and it operates so that partial surrenders or assignments of up to 5% can be made with any tax charge postponed until maturity or another later realisation. The rule is commonly referred to within the industry as the 5% allowance, and it is important to note this is not an exemption. The charge is deferred, it's not removed, but it may be the case that by the time the deferred charge is triggered, the circumstances of the person chargeable, whether it's an individual or in the case if we also have an offshore trust there, a trustee, they may have changed their circumstances so that no tax is ultimately payable. Therefore, although offshore bonds do not remove tax, it does defer it until the chargeable event occurs. And when that chargeable event gain is charged, it's to income tax, where the policy is for the benefit of an individual or where it's settled into a trust by individuals. So they can be very useful during periods of transition or relocating for clients, as they can provide a tax efficient income stream during those times of uncertainty, if clients don't know where they will be or how long they may be resident for. But there are just a couple of points to be aware of and things to watch, and many of you will have lots of experience as to how offshore bonds are run, and you'll know that the investments, the asset allocation, and product selection is essential, and timing is key there. So it's also important to recognise that they should not replace any surrounding tax planning. They are complementary and do sit alongside nicely with other structures and can act as that helpful regular source of income. From a point of view, there does need to be care taken as to who the lives assured are, and for there to be sort of careful coordination with any wider structures in place. So very much a topic of conversation we are finding at the moment, and can be very useful for the right client and the right specific facts. And so Toni, I think, is kindly going to take us through the next slide on family investment companies.
Thank you. Yes, so we're just going to have a little look at one or two structures which we're seeing clients still using, still talking about. The first one of those is family investment companies. So family investment companies, as David said, they're not new structures. We found that they have been coming up more and more in recent years. In particular, I think HMRC reviewed them back in, I think it was 2019. just to see if there are any sort of tax anti-avoidance issues with them or if it's something they should be investigating. And they ultimately closed their sort of special unit that they'd set up. So I think from a client's perspective, we can talk about them quite comfortably, knowing that HMRC understand them and know that they're not sort of a tax avoidance tool. So I won't go into what a family investment company is because I'm sure you are all familiar with them. But as David mentioned, we're finding that they are benefiting those who are looking to become sort of a long-term resident or perhaps already are. So sometimes they're used on their own, sometimes they're set up in conjunction with trusts. It really does just depend on the specific circumstances and the client's profile. We tend to find them as a tool that clients like to use if they've perhaps been through a recent business sale, or potentially just incorporating the structure as part of an ongoing trading business. It's just a way for them to pass down the wealth to the next generation. And we've just listed there a few pros and cons, I guess, of a family investment company that we found. The top one, obviously, being that mum and dad can essentially retain control whilst also making provision for the next generations. So, they set up the family investment company, they have their various shares of which they can attach the rights that they feel most comfortable with, and over the years can update that so that future generations can become more involved or receive more benefit. And with that comes the flexibility to distribute income. Obviously, as I said, different shares have different rights attached to them. So again, mum and dad can decide who should receive dividends, and when. It's important to stress, though, that family investment companies aren't a way to, get rid of tax, or it doesn't dissolve it altogether. There are ways that obviously tax can be deferred if the profits are rolled up inside the company. But obviously there are personal taxation, such as inheritance tax, income tax, when you're receiving dividends or when you own shares. As I've mentioned, it's an IHT planning tool. Your parents, again, are able to pass down wealth through the family investment company and get it outside of their estate. We've seen a number of clients use trusts within the structure to hold the growth. So the family investment company would hold the growth shares, and future profits would go into that trust for those future generations. It works really nicely along the new residence-based system. As we mentioned, these structures tend to work best for those that are already UK tax resident. So it's a nice alternative to trusts where they aren't perhaps as appropriate. There is a sense of relief in terms of the fact that these aren't offshore structures. As I mentioned, HMRC did look into them to see if there were any tax avoidance issues, which they concluded that there aren't. And I think we all know that there have been a lot of more investigations in terms of offshore structures and how they're used, in particular trusts. Compliance is really ramping up on reporting for all of these various structures. So I think family investment companies are something that a lot of clients understand. It tends to be a UK registered company that holds assets with shares. There's nothing really, to not understand about that. So I think there can be some comfort for clients in knowing they're not doing anything that could be perceived as avoidance. They interact quite well with business property relief and agricultural property relief rules. As I mentioned, we sometimes find clients use these as part of their trading business structure. Sometimes those structures have business relief that applies to them. So this is quite a nice way to incorporate those reliefs into a new structure. And the final one, again, kind of linked to control, but it's a good way to implement some family governance. There's been a lot of conversations recently that we've been having with clients and in the industry on family governance generally, and involving the whole family in discussions around how estate planning works, how parents are making provision for future generations. And this can be quite a nice way, again, it's very fact specific, but on bringing the whole family in to make decisions about future generational wealth and how that is managed. So we've included the very cheesy line in there that fix are not a silver bullet, but they are a very good Swiss Army knife. It's a good one to have for the toolkit. It doesn't work for everybody, but it's, clients do like to talk about them. So we've just mentioned that there. But equally as important, and Eva's going to have a quick run through of trusts.
Thank you. Yes. So, obviously, since the new rules, trusts, what has fundamentally changed? As mentioned already, the big shift is the move to the residence-based IHT regime, which has resulted in the fact that we no longer have the same certainty that offshore trusts will sit outside permanently the IHT net. Critically, trust status now can move in and out of charge depending on the settler's resident status at the relevant time, and this has been referred to as the ambulatory test. So that's a huge conceptual change for us as practitioners. And some may say that excluded property was not what it used to be. Historically, excluded property trusts were the cornerstone of non-dom planning. But now the protection depends on whether the settlor is a long-term resident at the relevant time and not just when the trust was set up. So it's sort of less of a set and forget and more of an ongoing exposure management exercise for clients and for advisors. But trusts still do matter, and despite the tax changes, trusts still offer control over timing and nature of distributions. They do remain the go-to for asset protection, family governance, and perhaps privacy. So put bluntly, their non-tax advantages have become more important, not less. Perhaps we may be seeing that they are at the moment no longer the default planning mechanism, but they are far from dead. And for the right client in the right circumstances, they are highly relevant and helpful. So we have just prepared three case studies to quickly run through. And so Toni is going to take you through the first.
Okay, so just to put some of the things that we've been talking about into practice. So we've got our first case study, the returning entrepreneur. So this one is mainly looking at the foreign income and gains regime and how a client might be able to benefit from that. So this is a classic client that we're seeing, internationally mobile individual, but he would like to spend more time in the UK to be with his family. So as it says there, he's been non-UK resident for 12 years and he's looking to return in the 2026-27 tax year. So because he's been a non-UK resident for at least 10 UK tax years, he qualifies for the foreign income and gains regime. So that means that he is able to bring in his foreign income and gains for his first 4 years of UK tax resident. And he's told us that he has a significant offshore portfolio with a value of around 20 million. He would like to keep it outside of the UK, but he wants to use those funds to live off while he's here. So very important that he's able to bring in those foreign income and gains. So what would we sort of initially be looking at when advising this client? So we've got a bit of time. He's not arrived just yet. So one of the first points we might suggest is that he looks to realise any gains pre-arrival. So essentially rebase the portfolio. So he's got clean capital there. When he arrives in the UK, then he's got his 4-year foreign income and gains window for his remittances. So he can bring in any future foreign income and gains without having a UK tax charge for his first 4 years. We might mention to him, just because we're in July 2026, that if he arrives partway through the year, it would count as one of his first UK tax years. So he might want to wait until April 27 and start next year. We also might mention, any potential structures that he could set up. So one possibility while he's not in the UK could be to create an offshore trust that could potentially hold an offshore bond. So he's still benefiting from the portfolio. He can draw down his 5% and defer the tax charge there. equally, could have no structure at all, keep things as they are, and just bring in the foreign income again for the first 4 years. It all very much depends on timing. Obviously, if he is looking at setting up a trust, he'd have to do that whilst he was a non-long-term resident. If he became a long-term resident and tried to set up a trust, it would be subject to inheritance tax, and he wouldn't be able to benefit from that. So that is case study 1. And I think I'm going to pass over to Eva just to have a look at the second one.
Thank you. So our second case study, we are looking at where long-term residents could be caught. There are sort of many little intricacies that have to be thought about. And here we have an international individual who has been UK resident for 12 out of the last 20 tax years. So from April 2025, he is classed as a long-term resident and now is looking at his worldwide IHT exposure on his assets. He may think this is not ideal as he does have an offshore portfolio and an offshore trust. We know the remittance basis is no longer available, so he decides to leave the UK, thinking that this will solve all his UK tax problems and he can escape those touch points. However, as mentioned previously by Toni, he will still have the IHT tail post-departure. So there needs to be a good analysis carried out on that to see how long that tail will last. In terms of his assets, the offshore trust, as mentioned before, the tax treatment depends on the settlor's resident status. So as discussed, the trust can move in and out of charge here in the UK. And so it is very critical that those types of clients revisit historical structures that they have set up to ensure they're not caught when they thought they could be safe after leaving the UK. So the take home really is residence drives income tax and IHT, but leaving the UK does not immediately remove that exposure. So just for clients to be alive on that point and make sure they take proper advice and don't find themselves being caught when they thought they were safe. I think David is going to take us through our final case study.
Thank you very much, Eva. Yes, indeed. So this is our last case study, and I'll just deal with it fairly quickly so we've got some time for questions. But it is quite relevant because it touches on a scenario we see a lot. So that's basically dealing with existing trusts that were established already prior to this budget for non-domiciled individuals. So as Eva said, the gold standard of the planning that used to be done before this budget is where you had a client who was qualified as a non-dom and was still not deemed domiciled in the UK. Broadly speaking, meant they had not yet been resident in the UK for 15 years or more. Then the gold standard was to establish an excluded property trust for them. And as long as that was done in the right way, that had protected status, it basically meant the client could continue to benefit from it, and the trust stayed completely out of the UK inheritance tax net. So many clients had established these structures, and the new rules, as we've said, do impact those structures and can make them much less efficient. It was part of the commentary behind the idea that some individuals and families with these sorts of trusts would look to leave the UK in order to allow these structures to continue to be efficient. And indeed, some have done that. But I think the point we wanted to draw out from this case study is that there are planning issues that can be done, and we have been working with a lot of clients over the last couple of years to alter and restructure trusts or adapt the way that the underlying assets are held to allow them to work reasonably well within the new regime. So there's not necessarily a need for clients to relocate just because they have these pre-existing trusts. So the case study we have here is we had a settlor who was non-domiciled under the old rules. They'd followed the advice. They established an excluded property trust with protected status under the old regime. Um, and the issues they have now are assuming they are continuing to remain UK resident and they and their family don't want to relocate, is that, as we've mentioned already, well, although this trust under the old rules was completely outside the UK inheritance tax net, that's no longer the case. The new rules mean that you have to keep testing the status of the settlor at any key point of charge under the trust. So you may be familiar with the fact that for UK domiciled people who set up trusts, we have this regime called the relevant property regime, which means the trust itself can be subject to inheritance tax, both on creation, but also once every 10 years on a 10-year anniversary charge, and also on an exit and distributions from the trust structure. Those exit and 10-year charges are not huge. They are at a maximum of 6%, but obviously they add up and they mean that the overall the trust is within the regime, the IHT net. And the position, of course, now is that if the settlor remains a long-term resident, then come every 10-year anniversary charge, there will be that 6% charge going forward. So that is a relevant consideration. It's not necessarily a deal breaker, though. In particular, there is a useful exemption that means that where this trust had been established before the budget, before October 2024, it's still okay actually for the settlor to be a beneficiary of that trust, and it won't be treated as being part of their estate for inheritance tax purposes on their death, as long as the settlor doesn't add anything further to the trust. So we do still have a good measure of protection from these structures. That obviously doesn't apply for new trusts being set up in similar circumstances. The other angle is looking at income tax and capital gains tax. That becomes very intricate and depends on the detail to a great extent. So I won't go into detail, but very broad takeaway is if the settlor can benefit from the trust, still then income is attributable to the settlor on an arising basis to tax. So that's not so great. And capital gains tax, similarly, all gains will be attributed to a UK resident settlor, even if they've been excluded from benefit, but assuming their children and grandchildren can benefit, which is usually the case. So the practical takeaway here is this is one reason why offshore bonds can work very well, because they, as long as you stick to the 5% withdrawals during the 20-year period, you won't in practice have an income tax charge arising, and the chargeable events don't trigger a CGT charge. Another practical example we've seen is gearing the investment policy of the trust to try to produce income rather than a gains treatment where possible. That can also be a useful planning tool that can be an interesting place for us all to pool our expertise. So I think, yeah, in short, trusts have lost advantages from under the new regime, but they still definitely have a place. So just to wrap up and just go to the final takeaways before we answer some questions, I think very briefly, as you have seen, domicile no longer applies for most tax purposes, but not all, and we'll come on to that very briefly in a second. It now is mainly, though, it's about residence and whether a client is a long-term resident or not. So it means being precise about whether somebody is resident is really critical, and looking back over the last 10 or 20 years is part of that planning. If somebody has become a long-term resident, then their whole worldwide estate is subject to inheritance tax. That's a big change, and that affects trusts too. But the good news is there are planning windows. Ideally, you want to plan before clients even come to the UK, but it's not, all is not lost. If they've arrived already, we do have this first 4-year window. During their first 4 years of residence, there's planning that can be undertaken, and it's really worth engaging with clients during that early period, but not waiting and seeing, because the longer that time ticks on, the more the planning opportunities narrow down. There's a lot of detail, there's transitional rules, the FIG regime is complicated, but the key takeaway, I think, is clients need coordinated, proactive advice from all their professional advisors, so investment professionals working together with tax and legal advice, and there's things that can be done. So even if clients want to come to the UK, there's much that can be done to help them work within and navigate these new rules. So I guess those are the key points, and then I'm conscious there's been a few questions in the chat which we could perhaps talk through, Huggy, and I've been having a quick look at one or two of them. I've got one or two thoughts.
Right, we will dive straight into that because I am mindful of the time. Thank you, first of all, to the three of you. There's lots and lots to unpack there, but very insightful. The first question we've had is, in theory, is it possible for someone to come to the UK for a day, which would effectively be a tripwire for them to become accessible for global IHT?
Yes, and that's a really good example of how these kind of questions that come up in practice. Very short answer is if the key thing to bear in mind is what's the client's history? Have they been resident in the UK over the course of the last 20 years? So that's one of the big questions to ask a client. It's not just about this year now. We need to look back. Um, and we need to check. The big test there is if you've been resident in some of the last 20 years, could this new arrangement trip you into long-term residence? Having said that, in this particular example, if you're literally coming to the UK just for one day, you should be fine because even if you have loads of other connections to the UK, under the statutory residence test, if you're here for less than 16 days, that will normally be definitive that you would not be UK resident, but it is very much subject to the matrix of all of the different interconnecting factors. So the key thing is to have questions out there, to be aware that the client needs to take account of other connecting factors, not just their day count. And those include accommodation available in the UK, if they're working in the UK, whether they have other family members who are resident in the UK, close family members, spouse or minor children, and their residence history. But basically speaking, one day by itself, you should be fine.
I have to say, David, I'm very surprised there have been tax changes that have made the situation more complex.
I know, who'd have
Seen
thought
that
it?
coming?
Who'd have thought it?
Um, the next question we have essentially is asking about if you have a client who perhaps isn't actually based in the UK, but they are paid as though they were, perhaps they're working for the government, and paid as a UK citizen. How would that work?
Yes, indeed. So obviously, it will depend a little bit on the precise organisation involved. The general rule is if you're a Crown employee, so you're working for the UK government or Foreign Office or equivalent, they do generally treat you as being UK resident, irrespective of where you have physically been. So unfortunately, you'd normally be within the UK tax net. There are some exceptions for specific organizations. So it's always worth just checking those. But that's the general point, starting point.
And I think we'll probably make this the last one. If the settler died 20 years ago, would the offshore trust still be effective for the surviving UK resident children or beneficiaries?
Yes, indeed. And that's a really good question. It will, one key point just to determine is what was the settlor's position when they did pass away. But in general rule terms, where a settlor died a long time ago, if assuming we were in the protected regime at the time that this was a trust that qualified for all the protections in the past, then it's very likely it will still be a very effective tool, particularly from the inheritance tax perspective for surviving UK beneficiaries. It should be, again, this is subject to numerous other caveats, in particular, making sure that the property, the underlying trust property is outside the UK, and has remained so. But if that's the case, then it should be protected and outside the UK IHT net. Very important to take advice on all of that. The bit that particularly will need planning, though, is on the income tax and capital gains tax treatment for those UK beneficiaries going forward. There's That's where a lot of these points we've talked about will come into play. So testing offshore bonds, hybrid structures could be very important in helping to sort of trap income, make sure that benefits can be provided to the UK taxpayers as efficiently as possible. That definitely needs some planning. But all other things being equal, it should be a very good inheritance tax protection tool, which is very valuable in the current world, much less opportunity to establish those kind of structures going forward. So well worth keeping hold of that trust, getting the right advice, and hopefully it will be a very efficient structure.
Brilliant. Listen, we are just about at time, so I will firstly thank each of our panelists for your insights today. Genuinely fascinating stuff, and I suspect a million and one more questions were we to have the time. But thank you for what you've shared so far. Thank you also to our audience for joining us. A copy of the slides and the recording is available. As I mentioned earlier, if you, as you close down the webinar, you should receive a survey. If you want to pop on there, if you're interested in a copy of the slides or the recording, your local BDM can get that to you. But thank you again, everyone, for joining us. Hope you enjoyed it, and we will see you on the next one. Thanks very much.
Thank you, everyone.
Thank you. Thanks.